Thank you for being here today at our 18th Annual Oil and Gas Summit. This is my special honor to introduce Wilson Pipestem, who will talk about Tribal Energy Resource Agreements, or TERA, an opportunity for an improved Osage Minerals regulatory environment. A little bit about Mr. Wilson, he has dedicated his career to protecting the rights of tribal governments and American Indians. He's represented and advised on a broad range of issues from treaty rights to minerals production to gaming. A graduate of Stanford Law School and Oklahoma State University, Wilson founded Pipestem Law in 1999. He's also a founding partner at Ayatan Consulting, a federal advocacy firm representing Indian tribes. Wilson served as lead counsel in Osage Nation v. United States, a case in which the nation agreed to settle for $380 million. Wilson played prominent roles in the enactment of the Violence Against Women Act reauthorization and congressional reaffirmation of the inherent sovereign right of the Osage Nation to determine its form of government and membership. The VAWA and Osage laws are two of only 3 instances in U.S. history that the United States Congress reaffirmed inherent sovereign rights after the federal courts had ruled those rights were extinguished. Wilson is a citizen of Oto Missouri tribe and an Osage headright owner. I've recently had the pleasure of working with him for a proposed constitutional amendment for the Osage Constitution. And he is also a sponsor of our event today. So help me welcome Wilson.
Thank you very much. Well, we're here at an interesting time in our Osage Nation government, the federal government, all the things that are going on. And I know tomorrow Assistant Secretary Tara Sweeney will be here to talk about any number of things, but I think will probably address what's happening on the federal rulemaking regarding these tribal energy resource agreements. So, the possibilities of what a TERA could do for the Osage, speaking here very specifically about the Osage Nation, the Osage Minerals Council, and what are the possibilities of a TERA. Now, it doesn't mean if we get bad rules from the Bureau of Indian Affairs, Department of the Interior, bad meaning I would define as not helpful to the Osage in our special situation, then I expect that the Osage Minerals Council and the Osage Nation will not pursue a tribal energy resource agreement. But we're now in the stage of advocating to the Department of the Interior about what those rules should look like. So at some point, if they do make sense for the Minerals Council, the nation, to seek out a tribal energy resource agreement, a TERA, then it'll be an option. But right now, the Congress has enacted a new law in December 2018. And the Congress said you've got basically a year to promulgate regulations related to this new law. And if you work in tribal government or you have ever had a lease of your land, or if you're an Osage headright holder, the laws have been changing over the last number of years. And one way that the laws have become more modernized is that with every single action of a tribal government, with a lease or in other circumstances a land lease, modern federal law and policy is moving away from having the Bureau of Indian Affairs approve every single one of them. Right? So there's something called the Hearth Act. It was a law that was passed a few years ago that instead of saying every time the tribe enters into a lease for their surface land, that requiring a Bureau of Indian Affairs approval, that the government, federal government, would approve a tribal law on leasing and then the tribe could do it itself without the secretary being required each time to make an approval. So a TERA is modeled on the Hearth Act. It's meant to be an opportunity for tribal governments to create their own law or regulation or a TERA. And so each decision that would require the Bureau of Indian Affairs to approve that, in this circumstance, usually a lease for lands for minerals exploration, would not have to occur. Each time, we could avoid the federal government having an approval each time. So instead they would approve the legal scheme for getting to a lease or whatever part of the minerals process you would like to take over. So what are the possibilities? The goal, the Minerals Council has said that a TERA could make sense for the Osage Nation, the Osage Minerals Council, if it improves the regulatory environment for companies to come do business with the Osage Minerals Council. And so the management of the Osage mineral estate would become more efficient, right? So that would be a requirement. So the streamlining of the Osage Minerals process, right now, that is largely a function, or exclusively a function of the Minerals Council. And then the Bureau of Indian Affairs has to approve that lease, and then they take it from there. So when you hear someone talking about management of the Osage Nation mineral estate, how much management does the Bureau of Indian Affairs do with that work? Anybody want to guess?
They manage it enough to hold our records back.
They manage the entire thing. It's not just holding the records back. They manage the whole thing.
Yeah, but they hold our records back.
So we have a leasing process whereby, or this, the place where we stand right now, the land that you are on right now, within the Osage Reservation, has remarkable history associated with it that led to this discussion we're talking about today. So every inch of the 1.47 million acre Osage Reservation, which is contiguous with Osage County, has a trust relationship or a trust association with the federal government for these lands. And that came because of the historical factors that we, the Osage, I think Chairman Everett Waller said this morning, we bought this reservation. Unusual for an Indian tribe to say, we purchased the reservation. But historical factors led to the Osages, where our last reservation was in Kansas. And there was the federal government was pushing the Osages to move to where we are now. And the Osages sent a man named Wadainke to look around here. Margot Gray, councilwoman, that's her. She's a descendant of that man. And they relied on him. My grandmother said he was a prophet. And they said they sent Wadainke to this land to look around and see what was here. And to say, what should we do about this situation where we're being asked to move? We've been asked to move many times. What should we make this move? And the way it was told to me, Wadainke came back and he said, there's something in the land. There's something in the land here that will ensure that our children and our elders won't starve. And for many years, our people have said, was that oil, is that minerals? Because that has led to significant production of oil and gas, but particularly oil. So I would say, though, that my dad Browning used to say that maybe he was talking about something that's more valuable than oil. Maybe it's the sovereignty of the Osage Nation over this territory. When we talk about the Hearth Act, when we talk about a TERA, it is the scary proposition of taking over some of those functions, taking over some of these federal obligations. Because anybody read Killers of the Flower Moon, the book? One or two? You see what happened. There's a snapshot of time where there was oil production and led to all kinds of things, and some of them were really, were harmful to the Osage people. And so the legal regime that was created in 1906, called the 1906 Act, was meant for the government. They created a legal scheme where they said this will be your form of government. You'll have a tribal council of 8. We will provide protection for you over this land. And our chiefs at the time, leaders at the time, said that we want to preserve the common ownership of the minerals of the Osage Reservation. And so this led to this unique hybrid trust system that is unique anywhere in this country and maybe the world. So now the land that you stand on, the minerals, are owned by the Osage tribe. And then individuals own the right to receive the proceeds of that. Anybody know what that right is called? It's a head right. It's a head right. So you're not going to find the word head right anywhere else in federal law. That's unique to the Osage. You also, people refer to a head right owner as a shareholder or an annuitant. So we have this hybrid trust system that was meant to expire in 1931. So the time leading up to 1931 was the era that led to the book Killers of the Flower Moon. But it was a time when it was, there was an understanding, and under federal law, that whoever owned the surface land after 1931 would own the minerals beneath. So there was a rush leading up to 1931 to buy surface lands from Osages who owned the land. Osage is one of the few tribes in the country whose lands were allotted to individuals, meaning there was a roll of a list of Osages that was created in 1908, and every person on that roll received one head right and the right to receive surface land allotments, meaning 160 acres, and there was a process whereby individuals would choose or were assigned lands. So that process led to the authority of an individual to sell their lands to non-Indians, but only the surface rights, the subsurface remained in common ownership to the tribe. So fast forward to 1921, May 1921, Anna Brown was murdered if you remember Killers of the Flower Moon, and Osages were made citizens of the United States that same year. So there was this time when we were moving towards a change in the system. In 1931, land ownership was being purchased by non-Indians buying up land. There was great value in a head right, and Osages had a significant valuable right, which was a head right. So that led to a number of bad things that happened during that era, but that system was extended and extended and extended in perpetuity now. That trust system that was in place in the 1906 and the 1920s, during the Killers of the Flower Moon era, I'll call it, continues to be the law today. So now, the Osages have uniqueness in their federal laws of the 1906 Allotment Act and the amendments. Nowhere else in Indian country, and it's created this system whereby the Bureau of Indian Affairs essentially runs everything. Right? So, but with that authority of the federal government becomes great protection. That's why over 100 years later, we still have this mineral estate and it's intact today. Okay? So now what the Hearth Act does is creates these possibilities for the tribe through the Minerals Council and the nation working together. Just take one part of that, whatever they choose, and negotiate what that agreement might look like on taking over part of the process. So the Minerals Council has said that we're only interested in doing this if this creates some advantage for us and our business partners to engage in some kind of business in a regulatory environment that makes more sense than we have right now. So right now, the American burying beetle, anybody seen one of the American burying beetle or know what that is? It's an endangered species. It's actually kind of an impressive bug. Don't tell the Minerals Council members I said it, but it's kind of an impressive looking bug. And there's a lot of them here, but it has shut down production in the Osage in many ways, our ability to drill. So we are looking for solutions with the Fish and Wildlife Service, and I'm actually, for the first time in a few years, optimistic we may find something in the next, hopefully few months. But that's the regulatory part, because the federal nature of this mineral estate and our relationship with the Osage Nation through the Minerals Council, all that federal law comes into play. Endangered Species Act, National Environmental Protection Act. Tomorrow, Tara Sweeney will be here. It's been 4 years since NEPA has been pending with the federal government. Hopefully, she will be able to answer some of those questions tomorrow. We're dealing with all this panoply of 1906 Act and amendments and all these other federal laws. So how do we make that more efficient? One is if there's some way to take over some of these environmental processes ourselves. That's one option. By the way, I think other tribes in the country have significant oil and gas or chomping at the bit here at TERA. Osage, we've got to move more slowly, I think, than other tribes because of these considerations. But there's an opportunity for an environment where instead of having NEPA at every turn, so when the federal government enters into a lease, the National Environmental Policy Act kicks in over and over in that process. So is there some way to take over that part of the process, tribalize, so to speak, that process, and take with it and separate all the laws that have interpreted the National Environmental Policy Act for many years, and make it our own, make it more efficient, and make it even, maybe even more effective. So that's one possibility. The idea also is how do the Osage get into business on their own? So instead of just taking a royalty in dollars and it gets paid to the United States, gets invested and paid out to head right holders every 3 months, how do we take some of that royalty in kind, meaning if there's gas, instead of paying 20% to us or whatever the number is, or paying in dollars, let us take the gas and market it ourselves. But how do we make sure it remains trust funds that gets paid out to our head right holders? So ultimately, the issue of TERA only makes sense, as the Minerals Council has expressed, if it means more revenue to our head right holders. That's the only way it makes sense. So what are the steps? Now, first of all, because we're in a situation dealing with the federal government beyond just leasing, first of all, we kind of unify the Osage Congress, the Minerals Council, and the chiefs around a plan. So that has been going on, and sometimes that's not as easy as it sounds. But I can tell you, Principal Chief Standing Bear and the Osage Congress have received this conversation very well. So I would say at this point, there's still a long way to go, but you're seeing Osage government and Osage leaders work together. And so everybody's moving carefully towards this, and there's still, again, they have to create the federal rules, but there's an openness to finding some way to do something that makes sense. So Osage leaders are doing their part here. Osage leaders have really come together and been careful about it because this would be a historical step to do it. But certainly we see that happen. So understanding this 1906 Act process and law that I've just been talking about, I mean, it's complicated. So if you take the 1906 Act and the amendments and the related laws, it's about 81 pages of law that's sometimes written in 1906 law talk, right? It's complicated, not to mention regulations and other associated laws and limitations, policies. Then direct advocacy to the Department of the Interior. We have submitted comments that are public. You can find them online if you go to the Federal Register site, type in ABB. There's all the things that have been, or TERA, and you'll see what the Osage Minerals Council has submitted. It is a description of the Osage Reservation, the laws we operate under, the uniqueness of this situation, and not only that, but the fact that so much oil has been produced here that only one other county in the country has produced more oil, according to one of our experts. So you can see what the Minerals Council has said in that. We've identified a couple of big issues that we hope will be solved. One, the applications for permits to drill, an APD, an important part of the process to help our partners get to a point where they can actually drill a well. Is that going to be something the federal government allows tribes to take over and be a part of a TERA Or is that an inherently federal function, they call it? We're still waiting on an answer for that. There's also issues about the federal dollars that go into the leasing process or the minerals management process, and how much of that will we then take over? What dollars can we use from the federal process to use it on the tribal side to carry out these functions? So also, developing meaningful allies on this. Not long ago, the Minerals Council sent representatives to the National Congress of American Indians. And we were in a room dealing with land and natural resources and the environment. And about 90% of the people there were there for the single issue of climate change. And so we're advocating for something to allow more minerals production. And fortunately, in the world of tribal governments, when you talk about tribal sovereignty and control of our own natural resources, that resonates even more than that individual situation you see in Alaska and other places in this country. But the National Congress of American Indians unanimously supported the Osage Minerals Council's view that the federal government should create TERA rules that make sense for those who want to exercise authority over their natural resources, oil and gas and otherwise. So those are some of the steps. Now I got into a bit the framework that we're dealing with here, and that's directly relevant to what a TERA is. Osage, it can be a little bit complicated, as I mentioned. How is that? And special note to some of the Osage Nation congresspersons who are here. The Congress, Osage Nation Congress, you have a three-branch government, judicial, Osage Congress, and the chiefs, right? So the Osage Congress has a provision that gives them the authority to enact laws related to natural resources within the reservation. Right? The Osage Mineral Council has authority under the Constitution to basically handle all minerals matters. Basically leasing. This function today is carried out by the Minerals Council. Meaning, how do we promote the mineral estate, find new partners, get together, solve problems, that sort of thing. Those are authorities that belong to the Osage Minerals Council. So, not only is that approved leases, but other forms of development. This is one of those other forms of development, right? How do we get, again, people here talking about what's happening, where we think things are going in the Osage with regard to minerals development? And how do we ensure, because I know there's been concern, some head right holders have said, do not even talk about this TERA. Don't even talk about it. You know why? I'm afraid the tribal government's going to try to keep the money and not go out to head right holders. Well, Osage law does not prevents that from happening. So does federal law. But head right holders, shareholders, annuitants, they have a fair concern. What does this mean for us? We are ultimately the end recipients of the dollars from the Osage Mineral estate. So that's an important one of the laws. Now here's another one that's very important. The Osage Minerals Council is an independent agency under the Constitution with no legislative authority, meaning they can't pass laws, that's the role of the Osage Congress. But they do have authority to enact regulations. They do have authority to regulate the mineral estate. I would expect that you're going to see soon the Osage Minerals Council flex some of that sovereign muscle in ways that, in partnership with the regulated community, our business partners, there's a lot of problems that we have now, we're facing in the Osage that is shutting down development. You've heard some of that today in the larger session. What can the Osage Nation through the Minerals Council do to solve some of those problems? Where the Bureau of Indian Affairs does everything, even situations like right now, we can't get a hold of records, federal records. Right, so somebody wants to do business with us and they want to see well records. Councilman Revard can talk about this all day, I'll just give you a hint. We don't have the records, right? It used to be you went to the agency and you looked at them, but FOIA was enacted. The act that says that if there's a federal record, it has to be reviewed and redacted if there's certain information. So what do we do about that to fix that? Well, the government is now providing us information, but that requires a team of lawyers to review those documents and get them to us, redact certain information, and that's slow, right? But is there some way through our own regulatory authority that on a going forward basis, our business partners, instead of just submitting that information to the Bureau of Indian Affairs, they also submit it to the Osage Minerals Council up front, so we don't have to go to them for documents and go through FOIA again. Now, we'll see. We'll see. I mean, that is the kind of thing where the council, through its own authority, can create efficiencies in the process, independent of TERA, independent of the federal the 1906 Act and the implementing regulations, but we'll see. The other thing that matters here is that all funds belonging to the Osage tribe, that's the the tribal government and the head right holders of individuals, are all held in trust. So to the extent the tribe is trying to either take oil or gas in kind, market it itself, get more of a market rate for the oil, which we aren't getting now, get more of a market rate for gas, which we aren't getting now, and make money on, how do we make sure that money goes back to head right holders? That's a question. So this is also how you sue the government, this fund, by the way. So this is having litigated for 11 years this case. I mean, this is a specific provision about the obligations of the government to manage those funds. And finally, if you see this last provision, it's all things necessary. The Secretary of the Interior has enormous authority here. This is a broad, you not only have the 1906 Act, but you've got the Secretary with broad authority in the area of minerals, Osage Minerals. So that matters in the context of TERA. So this is a quick look at our existing federal regulations we have now. Most would say they need updating. In fact, there's been a long process to try to update these regulations because at this point, there's a belief that we do not get market rates for oil and gas. How does this become more efficient? And there's been a proposal to do this. The Minerals Council objected for a number of reasons. It was in litigation for a while, and that's probably on the agenda for some time in the next year or so, maybe more. We'll see. But again, all of this is to say the superintendent, the BIA, the Osage agency, sort of runs all this, has enormous obligations. So the TERA, again, was passed at the end of last year, December 2018. It amends an old law that was passed in 2005 that was so bad that no single tribe in America took advantage of the TERA. It was so full of bureaucratic problems that not a single tribe, not Southern Ute, multi-billion-dollar energy tribe, nobody took advantage of this. So that's what led to these amendments and the possibility there could be something useful there. So one of the most important parts of this, of the new TERA, is that to the extent there is a significant operation going on at the Osage Agency, if we enter into a TERA, that we being the Osage Nation working with different branches of government, the Minerals Council working together, if we were to enter into a TERA, do we have to take over everything? Which is a really big endeavor. Osage Minerals is a massive endeavor. There's a lot of systems in place there. There's a lot of personnel there. And what it says is, no, you can take a tiny sliver of it and leave the rest and try it out. Is it working? Can you make it work? And if it doesn't, you can just turn it back over. Right? So the TERA has this promise to it that in this part of the law that says even if, say, the Minerals Council said, we just want to take over leasing, which we already pretty much do. Right? We already play that role. That we could get federal dollars for that. We could avoid some of these federal statutes that make the process enormously inefficient. The time to get a permit to drill is, anybody want to guess? I can't remember the exact answer, but if they're super efficient, Councilmen Formula?
We have we've got 69 drilling permits out there right now, and the longest one is 322 days to get a permit, and there's several that are 283 days and 189 days. So it takes a very long time, much more than the rest of the world.
So, and that's true of all of Indian country, by the way, but for us, we're trying to, chisel that down by changes. How is there some way to do that? So,
Can I make one comment like this?
yes, sir.
We've had a number of permits that have been anywhere from 3 months to 6 months, that for American brown beetles being positive 3 years in a row, aren't even part of that number.
Yeah.
And it's not the BIA's fault, it's because the beetle is there present and we haven't had a way to deal with it quite yet, although that is starting to turn.
Right.
But, so we have permits 3 years in the making.
Right, so what this gentleman said was 3 years in the making trying to get to a permit, with the primary hurdle being the American bearing beetle. Right, I mean, we have those beetles here, right, but we think we've got a pathway to some solutions, some long-term, but that's, it could be long-term. Minerals Council is not willing to wait that long. They're trying to find interim solutions and investing in that, and we'll see. I think there is some opportunity there. So the TERA, if you submit a TERA, the government has to make a decision within 271 days, because what is it most easy for any governmental agency to do? Not do anything, right? In this one, the law compels the agency to either take action, to deny it, or it just automatically goes into effect. And it only says if you want to disapprove, you can't just take a pen and write disapproved and send it back. You have to, there's 4 things that you have to demonstrate that they did not meet one of these 4 criteria. So it forces the Bureau of Indian Affairs, the Department of the Interior, to take a hard look at it and approve it and act on it. And it says capacity determinations, the tribe has to have the capacity to do it, and I think the Osage Nation, I think easily meets these capacity determinations, because one, they've already got a Hearth Act, and my understanding is our audits are good, so we meet those. So what is one of the controversial parts about this is that to the extent we have the Osage Nation and the Osage head right holders have a trust relationship with the United States, and it doesn't mean, well, I really trust you. I think you're wonderful and I'd let you take care of my kids, No, it's not that kind of trust. It's a legal trust where there is a trustee, which is the federal government. There's a trust corpus, which is the mineral estate, and the funds that come from it. There is a trust beneficiary, in this case the Osage government, and then on the back end, the mineral head right holders get the money though. The tribal government does not handle the money at all. The money goes into federal accounts, invested and paid out. So what happens though? Say the Minerals Council enters into a lease and they've got a TERA, and they say, okay, we want 15, the 2 parties say, I want 15%. No, I'll give you 20%. They say, we land on 15%. And all of a sudden, it's enormously successful lease. And the Minerals Council said, I knew we should have stuck with 20%. They cannot sue the BIA for not approving and making them have entered into a better rate for the tribe, right? It means if you negotiated some part of this agreement, you can't sue the government for it, but you could sue the other partner if there's some sort of fraud or something else. So it doesn't mean you're without any legal recourse, but that is a significant thing to point out. That is a trust relationship, but if you negotiate some business agreement, you can't sue the government for your own screw-ups. Okay? So I think just on the face of it, these terms, it means that you now have a limitation on the term of the lease you can enter into of 10 years.
Even if you're producing it, you still have to go back and negotiate?
I think so. I think that means that's at the top end of it, but then you can write into a different parts of the lease or into your own TERA. Okay, here's the other part. Now this is controversial, right? This is a matter that says, hey, if the Department of the Interior is exercising authority related to minerals, and the tribe says, okay, we're entering into a TERA for that part of the process, you have to give us your money for that. We are hoping that this new TERA reg says exactly the way that I described it. Now, I'm hoping that the government does not have a different interpretation, but this is what the provision says. And it always said, every statute says the cost-related savings for tribes is contingent upon appropriation. So if Congress doesn't appropriate any money to the BIA to do this, then there's no money to be had. But that is something that still, we'll see what gets worked out. In the legislative process, our understanding is meant to be different than a 638 contract. TERA stands alone and is meant to create a separate pool of money that comes with those responsibilities. Okay. So the new TERA law creates some new possibilities. Now again, it might not be right for the Osage. We don't know yet. The rules aren't even set. But it could too. It could. And again, this doesn't make sense unless it improves the regulatory environment for the tribe and our partners, and ultimately leads to more revenues for head right holders. Okay, any questions? Yes, sir.
Talking about the price of oil and natural gas. How could we improve, because it benefits both the producer as well as just the Osage Nation to get better pricing. You mentioned a couple of times that the pricing appears to be not as great as it might otherwise be. We want to be able to do that for you and are open to suggestions on those kind of things. The natural gas market is even worse because it's devastatingly low prices.
Would you please repeat the questions as they're asked?
yes, yes. Okay, so again, we're talking about oil and gas prices. How do we work together to find the common interest in getting more money to head right holders and more money to partners? And right now, that's just defined by regulation, right? We have regulations that are very specific. It's called the highest posted price. Anybody heard that? Now, Osages, I grew up going to tribal council meetings, and people said highest posted price, which meant that the Osages are way up here, and then everybody else kind of gets market rates. Turns out that's not what it says. Right? In fact, there was a deal one time where there was an agreement to take oil in kind, and the companies just said, just give us the oil in kind, and we'll take it and pay you what you would have gotten otherwise. They just took it and marketed it in Cushing. You're wondering, how do you get more money by just taking it to Cushing? Well, it's because we were getting paid a discounted barrel at our highest posted price. So that's the rule that's in place now. So I think it's not about the price of oil, which is somewhat out of our control, but it's the regulations and the regulatory environment that impacts that price now. Finding a balance that makes sense for our business partners and also maximizes profits and income to head right holders is the goal. But I think that's an area that's really been the focus of why the CFRs were not finalized last time. There was a lot of controversy over that, and so trying to find out what makes sense there, I think, is still going to be something we're going to have to work through. Yes, ma'am. I know we had a question here. Yes.
Okay, everything that you said, what I'm hearing from you is that if the Osages, if we participate in the term, participate in the negotiation, then we won't be able to hold the BIA accountable. We won't be able to sue them. Is that what I'm hearing from you?
Well, for that limited part, right? So let me tell you, having litigated a case, again, we sued the government. We were in court for 11 years. We settled for $380 million. Suing the government is not a great option, right? They defend with the Department of Justice. And we were able to demonstrate, we had some very good court cases at the same time Cobell was going on. We were winning, and all of a sudden Cobell started tanking on the law. and started to undercut the rulings we were getting, and so we ended up settling. And unfortunately, those cases in Cobell did not get to the Supreme Court before we were able to settle it. There was a lot of factors that went into that. But it is the case that under this law, if you enter into a TERA and you negotiate some business term, and you as the tribe mess it up, you can't sue the trustee for it. You can sue the business partner under the contract, but you can't sue the government if you enter into it. Now, to me, that option is suing the government. Boy, you better have a big case, because they can spend, the Justice Department will tell you, we're really limited budget on being able to spend it. It's the federal government, the Justice Department. They have a lot of resources to hire experts and litigate for a long time. We were in court for 11 years before we settled. We could have been in court 9 more years probably to litigate that to judgment. So suing the government is sometimes absolutely the right thing to do and necessary, but it is a very expensive and very slow process to do it. Yes, sir. Councilman Brewer.
Yeah, thank you, Wilson. I may have missed it, but this law, the TERA, it was put in place in 2005, correct?
Yes, sir.
And it was not taken advantage of by any of the tribes for various reasons. But it was amended in late 2018.
December 2018.
December, okay, and so it's my understanding that this law is already in place, that they are currently working on regulations as how to administer the TERA.
Yes.
And they should have that finalized, I think, by December 18th of this year.
December 18th, but we'll see what Tara Sweeney says tomorrow. She may have an update on that.
Okay, so, and then there's, I hear from a lot of the head right owners about this. A lot of them are really scared. Like you had mentioned, some head right owners are concerned that maybe the nation, Chief Standing Bear, will somehow get control, that might get control of the funds where their head right checks wouldn't be issued or issued like they are now. That's a big concern of the head right owners. But if I remember right, from meeting with the director of the Bureau of Indian Affairs last week, this issue came up about TERA. And we talked about the funding of TERA. And I may be talking out, something that might have been confidential, but I don't think so. I think he point blank told us that the TERA didn't come with any funding. That we would have to seek out something like a 638 program to fund one of these functions that we might want to take over. And when the federal government came to us July the 11th in Tulsa to introduce TERA, there was a lot of ambiguity and misinformation and conflicting information, particularly around the funding and what functions that we could take over and which ones we could. Of course, we would want permitting and well record maintenance. Those are the two high priorities that I can think of. Leasing was an issue. Did we still have to have the superintendent approve a lease? Because by doing so, that is a federal action which triggers NEPA. So these are just some of the concerns that our head right owners and a lot of us have.
Yeah, and I think fairly so, but there's 3 issues there, right? One of them is leasing. And I don't think under any circumstances that would not be something that could be included within a TERA. The leasing process should be something that squarely fits into a TERA that would not require the superintendent to sign off on every single lease. We just do that. But there are several federal statutes that say when there's a federal obligation, it triggers these other federal laws. And maybe that creates some advantage for the Osages and our business partners to avoid all of the law associated with some of those statutes, because courts have interpreted them and there's NEPA's been around for a long time. Is there some way we create Osage law that essentially does the same thing, but we define what that environmental protection means? With regard to funding, I may be speaking out of school now. Can I speak out of school, Councilman?
I believe so.
Okay. So we're both not out of school. So the career head of the BIA said TERA comes with no funding, right? I think he's just wrong. And he's been a great advocate of ours, so I'm not saying this is a bad guy for saying it, right? No, he's an advocate for ours and has been good. But I think he's wrong about that.
Okay.
And hopefully that we can convince them, or the solicitors within the department will correct that, but they're still, it's not December yet.
Yeah, if I can, I work with Wilson and the Minerals Council. As far as the funding agreement, the amended TERA, the actual law that the regulations have to be built off, it's not a discretionary, it's not discretionary language that's used in the funding provision of the act. It says the secretary shall make available to implementing tribes at their request the funding that the secretary doesn't use because they're not administering the energy programs for that given tribe.
Great.
So I'm not really sure where they're coming with, unless they just haven't read the new amendments.
Well, again, as Abby said, I think that we may have a respectful disagreement on this, and we'll try to resolve that. Hopefully we'll resolve it the right way. Yes?
You said you made a statement that the Osage Nation in militants that are part of, or whatever the minerals estate. So I'm just curious, we talked about all the things that it's gonna do, possibly may increase the benefits for the militants. So how's the nation, what do they get out of it? What is their benefit for doing this?
I think their annuitants would be happier with them as political officials.
Is that it?
I think so.
Do they get any monetary for helping develop the, I mean, Tully and them, they talked in the last session about nationalizing. How does that work?
Well, nationalizing, and how does nationalize, I'm not sure the specific question. But let me say this, if you believe the 1906 Act and the amendments are still good law, which I do, then I believe that the tribe owns the minerals. Tribal government owns the minerals. It's not the individuals that own the minerals. If you believe in the 1906 Act, that's what it says. Okay, we can disagree on that. But what a head right means is that you get the money from it. But it does, and it certainly does not mean that the nation can take the money, because that is prohibited by federal law over and over and over again. So, including Osage Nation law, right? So, when you're talking about the nation or nationalizing, so if I think I know what you mean, if say the tribe does something like I described earlier through the Minerals Council and says to its business partners, when you submit information to the BIA, you need to submit it to us too. And we're going to issue a regulation that says, copy us so we don't have to go to them for your records. I think that's an example of nationalizing, right? Because now we spend a lot of money trying to get them to give us those documents. And then they say we got to spend attorney time to redact. So tell us what you really want. Let's negotiate that. It's got to go through FOIA. So why should we do that? When you can, if you can just give us the documents up front, we'll create our own database. To me, that is a way of becoming more efficient. It helps our business partners because we have the information that they can look at. And instead of going through some federal process of FOIA to get those documents, we exercise that authority ourselves and get the documents up front. That's an example. Yes, sir.
Did the 1906 Act specify who owns those documents? They're just your trustee, aren't they board documents?
I don't think there's anything in the Act about itself about documents, but there are federal definitions of trust records. And pre-Cobell, it was a time when you went to the agency and looked at them, right? Now, because so many records were lost or destroyed, there's a lot more law about preservation of those and access to them. Now, that's causing us a problem. You know, our leadership has identified that as a problem, but how do we, we're looking for ways to solve that in a difficult, when those have become federal records now, trust records.
So you don't own it, or there's not been a decision verbally. Why can't they just make a copy and give it to you? Then there's no loss of record.
Because some of it has information like John Doe owns X amount of, and their address and their personal information. So that's the FOIA part. That means some lawyer's got to review it and redact it. And that's a pain in the backside to do all that, right? I'm getting the gong here. So I'm around if you have any questions, so I'll be glad to answer any other.
FOIA, wasn't it implemented in 1974, why they just now getting around to pushing for it now? Is it because we took the highest level price of settlement money?
Not at all. Records have nothing to do with that. FOIA has always been in place. But those, well, that's it. If it's still the law, it's still the law. I don't know if there's a better answer.
Took the money. What do you expect?
That's,
the money.
I disagree with him on that.
Well, I do too.
Thank you very much.
Thank you. We have a gift for him from the Summit Committee. Which one? That one?